Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. Today is May 24th, Thursday. We do a bi-weekly community conference where all are welcome to join in and ask your questions. I have been incredibly busy these few weeks. It's just I haven't even had a chance to review your questions. So what we'll do is I will review the questions as we go along. And if you're on the phone and if I've misunderstood your question, just let me know. Or if you have any follow-up questions, we'll do as usual. So let's get started. The first question is from New Andhra, who's working on 485 AOS EAD and did AC21. Joined a company before 2017. In those days, we didn't have the supplement J issue. EAD is coming to renewal. When do I submit the supplement J? Okay, so it is my understanding, I could be wrong, but I am quite sure that government has said that hold on to supplement J until we ask for it. But I don't know of any other procedure through which you could do a supplement J along with the EAD. Of course, you can file a supplement J by yourself at any time, separate from your EAD paperwork. You can do that now if you want, but my understanding is government has encouraged us to wait until they send an RFE. But I see absolutely no harm in submitting supplement J now, separate from your EAD paperwork. *5 if you have any follow-up questions on this issue. Press *5. Okay, we have one. This is a blocked caller, so I don't know where you're calling from. Go ahead if you have a question, please.
Yeah, I'm the New Andhra, Rajiv. Actually, there is no harm while submitting the supplement J form, right?
Zero harm, because at the most what will happen, if they send an RFE again, you can send the same supplement J again. So I don't see any issue with submitting it. Okay.
Okay, thank you.
Good luck, sir. Okay, next one is Pramod Krishnani. H1B 6th year expiration is 2018. PERM applied, then PERM got approved. I-140 filed, premium processing. RFE was received about ability to pay. Okay. All right, the company is doing well. Okay. Is it normal to receive RFE with ability to pay? Oh, yes, absolutely. It is very, very normal. Of course, you have to respond with a great deal of attention to what they've asked for. But these cases are not that difficult to win if the company is doing well financially. Premium processing does not cause RFEs any more than normal. I have not seen that in truth. Probability of success depends upon the merits of the case. Ability to pay wages is usually pretty easy to win, like I said, if your company is doing well. Can I extend my H1B if I-140 is pending? Not only can you extend your H1B if I-140 is pending, you can even extend it if I-140 is pending, gets denied, and you file an appeal. So you get 1 year extension. I have a travel planned. Okay, so Pramod, are you on the phone now? Do you have a follow-up question? *5. Okay, good. He's here. Yeah, Pramodji, go ahead.
Hello, sir. Hey, Rajiv, thank you so much. I appreciate this. So, one small correction in my PERM applied. The PERM applied was actually as 8/9/2017.
Okay.
So just a small change there,
Still, the only thing that matters is your company's ability to pay wages has to begin from the date PERM was applied. So instead of submitting tax returns for only 2018, there'll be, of course, 2018, August is not possible. So they would have to submit 2017, 2018, and 2018 is not yet over. So normally submitting tax returns of 2017 is all that is relevant here. Okay.
Yes, and so what happened is they have already applied. They responded back on Friday 11. So on 11th of May, they've applied, and I got a status note that it's in review and it's done in premium processing. And yeah, that's definitely the company is really good. It's one of the largest and one of the top 10 solar company in the in US right now.
Excellent.
They're
I don't
doing
see
really
any
good.
problem, Pramod. I think you'll be fine. Don't worry.
All right. Thank you, sir.
You're
Appreciate it.
welcome. Good luck. Next question is contact GS. Here is the background. So there's a lot of facts, so I don't know what you're asking me. I'll read the questions first. Can I continue to stay in the US until the expiry date, 31st May 2019? What is my legal status? Would the perm go in pending status after appealing against the perm denial? Well, if a perm denial is appealed, you can keep getting H1 extensions beyond 6 years on a yearly basis while the appeal is pending, and perm appeals typically are pending for 3.5 years. So I'll just clarify that generally speaking. Do we need to file an H1B extension with the second green card perm with priority date of 15 June 2017? Yeah, you can file for the second perm that was filed, and I'm going to go review your facts again. And even if the first green card perm is already withdrawn, that shouldn't affect you. You can't really use that. So it looks to me like what happened was there were two perms. One was denied. I'm just reading the facts. Today I didn't get a chance to review these questions beforehand. I was very, very busy. So I'm just trying to read as I go along. If I miss something, let me know that I've missed a point. So what happens is once an extension of H1 is approved and later on, let's say the perm gets denied or withdrawn, government won't take away what they have already given you. I think technically they could, but as a practical matter, I don't think they can. It's very difficult to keep track of these cases. So your questions, let's see. Yeah, so I guess you got a 31 May 2019 approval based upon the previous perm, and that's fine. Even if it is withdrawn later on, that should be okay. What is your legal status? Arrived in US, completed 6 years, joined with current employer, first priority day, first perm filed. There was an RFE. RFE on the H1B application. While responding to the RFE, the attorney asked for an additional year of H1B extension. Okay. H1B got approved for 2 years. That sounds okay to me. If you got the H1B approval for 2 years, but were you entitled to an extra year? 2012 you came in. So till 2018 you would have gotten H1Bs anyway. So it doesn't look like you have a problem because 31st May 25th February 2012 to, I don't know how you got it to May 2019. You may have traveled outside USA also. So it overall, just from a generic broad perspective, it looks okay to me. I'm not sure exactly what your pinpointed questions are. I think you were concerned about the fact that your old application was withdrawn, the perm, based upon which you got the H1B extension. I don't think that should be an issue. Okay. *5, if you have a follow-up question on this, *5. Okay. Ram Kumaran, my employer filed labor perm 2011. They entered my master's degree completion as 2003 instead of 2002. Oh, didn't I deal with this question the last time? My labor was denied in Jan 2012. We applied in Balka for appeal. Last week, Balka perm also got approved. So the issue is, there's a date wrong. Does this make a big problem? And the answer is, you don't have a choice. File the I-140, see what happens. And I think I answered this question the last time also. Maybe from you, maybe from somebody else. But this question was raised, and I said, there is no mechanism to correct a typo on the perm once the perm is approved. So you have no choice. It isn't like you can go back and get this corrected. Go ahead and file the I-140. Let's see how it goes. *5. I don't think it's going to be a problem. It looks like just a small typo. It doesn't affect the case. So, yeah, New Jersey, go ahead, please.
Hi, sir. This is Ramkumaran.
Yes.
So, when file I-140, will they say reject my I-140 because of the year is the wrong one?
No, I don't see why. I mean, to me, it appears to be an inconsequential error. So I'm hoping that it won't come to be a problem. Under Trump administration, they have tried to find every excuse they can to deny cases, but there is a limit beyond which even they cannot go. So I don't think this is going to be an issue for you. You should be okay.
Okay. Thank you, sir. Thanks for information.
You're welcome.
Thank you.
Next question is from Chris EB2, sorry. Chris EB2 says, when I filed my DS-260, I answered no to have you ever been arrested. I forgot to mention I had 2 parking tickets. Parking tickets are not an arrest, sir. So, no, I don't see that as a problem. Not at all. Not at all. I don't see that as an issue at all. So, parking tickets are not a problem. Actually, when you file for naturalization, I think the form itself tells you. You can take a look at it. N400, the naturalization form should tell you you do not need to disclose non-moving violations. Okay. *5, if you have a follow-up question. I don't see a problem with this, Chris. *5. Okay. Let's go to Sadiq SSP. My wife's H4EAD is expiring November 4th. H4 is expiring 2020. I was not aware that I can file H4EAD with H1 extension last year. My question is, since the EAD processing times currently take almost 5 months, can I apply for H4EAD 150 days prior to expiry? I believe so. I think it's as, I could be wrong, but I don't remember all the details, but I think you can apply as early as 180 days ahead of H4EAD expiration. Are they taking away the H4EAD? Well, they're going to try. We'll see how that goes. They have, excuse me. What happened was there was a lawsuit in Washington, D.C. where the government said, okay, we are going to take away these regulations in June. So we'll see. They'll have to publish a proposed regulation to take away the existing regulations. We'll all respond to it. It'll take them a few months probably to go over all the comments, and then they will issue the final regulations. And then if they don't get sued over it, then only the regulations, the H4EAD will go away. Okay. *5 if you have a follow-up question. Okay. You are from, I guess, Texas. Go ahead, please.
Yeah, so like the follow-up question would be, so is it wise to file H4EAD now? Because if they take it away, whether they will keep H4?
Absolutely. Because there is a possibility that the regulations might not disturb those EADs that have already been approved for that duration. There's a possibility. So it doesn't hurt.
Okay.
Okay.
Okay, got you. Thank you.
You're welcome. Okay. Let's go on to the next one. H1B IMI. I'm on H1B visa and my I-140 got approved in 2011. Same employer got my extension approved. I was convicted for DUI and in November I consulted Rajiv. You talked with me, I guess. I got the certified copy of the court disposition. It was a misdemeanor. Last time I went to India, attended in-person interview, you got a 221G. Yeah, that's normal. I also told you that when you go for a visa stamping, I always tell people they'll have to go through an addiction examination. No, I don't think they're going to do it again, sir. I don't think they'll do it again. So there's only one arrest, right? You said that I got arrested for DUI in Atlanta, Georgia, but currently I'm living in North Carolina. Do I need any additional documentation? No. If there was only one arrest in your background, one DUI conviction, I don't think you need to worry about it. It's not, I don't see that as being an issue again. *5 if you have a follow-up question. They might delay your visa a little bit because they have to go through the records, but I don't think you have to go through the psychiatrist panel again. I don't think that's going to be an issue. I'm glad it worked out. Okay, then next question is from Fuzzy, New York. This is about cross-chargeability using my spouse's country birth. Timeline for EB2 485 based on cross-chargeability. We both got EAD-AP combo in December 2017. Heard from the USCIS call center that this interview requirement is not for all EB applicants. No, they are calling everybody beyond a certain date. So I don't remember exactly. I think it was May 2017 or something like that. Anybody who filed after that would be definitely called for an interview. People before that may or may not randomly get picked up. We are now going through a divorce. Spouse is not willing to attend the green card interview. Should my green card get rejected because I used her? Well, this is a very interesting question. You used her country of birth, but you're not yet divorced. So if you are asked this question, you can let them know we are still married, but we are separated. Okay, we're not divorced. So that's what I would do. I think you should still be okay. I would argue, if I were representing you and your lawyer could argue, that until you are divorced, you're still married. It shouldn't be the government's concern whether tomorrow you're going to get divorced or not. The fact is today, when you're getting the I-485 adjudicated, you are married and you're using her country of birth as you're entitled to. I don't see any issue with that. At least that is what should be argued. *5 if you have a follow-up question. *5. Okay, go ahead, please. I can hear you. Go ahead.
Thank you so much.
Of course.
So you're saying that if she's not present at the interview, how can I prove that we are still married and just separated?
Well, look, it is impossible to prove the negative of an assertion. Okay. If I tell you, prove that you have not eaten your lunch, you can't prove that. You can prove that you have eaten your lunch. It is very difficult to prove the negative of an assertion. Or even something simple like what you asked me, prove that you are not divorced or prove that you are still married. Well, you can't really prove that. You can just say what you are saying under penalty of perjury, and that's a sworn statement. That's good proof.
You think I will be okay to go along with the interview without withdrawing her application?
I don't see why not.
Yeah.
See, you're not divorced yet. I've always had a problem with government creating a stink about it. Until you are divorced, you're still married. If you wanted to get married to somebody else, you legally cannot. So if you have all the legal limitations of being married, why shouldn't you enjoy the legal rights of being married?
Okay.
Okay.
That'll be fine.
Good luck.
Thank you.
Bye-bye. Then we go on to Vic, who is Win16. I'm on H1B with approved I-140. Parents have a 10-year B1, B2. I want to sponsor my mother as a nanny. You can't do that. There's no such thing. The so-called nanny visas, which are H2Bs, are not available for India-born people. Not a reasonable approach. Don't even think about it. No, that's not a possibility. You can apply for her green card if you're a citizen. Are you a citizen yet? No, you're on H1B. Well, it's an interesting provision of the law that H1B dependents B2 can be extended just like an H4 if there is a reason for it. I'll give you an example. We had a case of a physician's mother who had diabetes, very severe diabetes, and she was alone in India. So one son was on H-1B, the other one was a US a green card applicant. So we were able to keep extending her her tourist visa based upon the fact that she needed to be taken care of, and that the law does allow you to extend these kind of visas for derivatives who are not qualified as derivatives. So if you have, it used to happen earlier for gay partners. So if you are gay and you are in a committed relationship but your country doesn't allow marriage, you could bring in your partner. You can't do H4. In those days that was not allowed. You could bring in your partner on a B2 visa and keep extending it. So you might want to consider that, but certainly she cannot be a nanny. If she does that, she's taking away an American job. That's illegal. *5 if you have a follow-up question. Okay. Area code 217. Go ahead, please.
Can you hear me?
I can hear you, yes.
Okay, sorry, that question wasn't my question, but I was wondering if I could ask a related question or wait till you go through all the questions.
If it is related to a nanny visa, you can ask me.
It's not related to a nanny, it's related more to fiance, and I'm a green card holder. I can wait.
Green card holders don't get a fiance visa. Yeah, just wait. If we have time, I'll call on you.
Okay.
Thank you.
Okay, thank you.
Okay. Yeah, we are going through the questions quite well, so we might have a few minutes left at the end. Adil, Michigan. Wait, we did that Wick's case. Yeah, Adil, Michigan. My question is, when should I invoke the AC-21? Should I wait for an RFE or should I file it after 180 days? It is safe to invoke AC-21 after 150 days. Well, my 485-131-760 was filed by employer ABC Corp. It has been 160 days. File a supplement J only after 180 days. That's what I would recommend. *5 if you have a follow-up question. *5. Okay. Next question, Road Train 64, currently on H4EAD, valid till 2020, working on H4EAD for client A through employer B. Employer B filed H1B. I'm selected. Client A has offered me full-time position. They want me to accept as soon. I can't wait. I want to accept this full-time position without jeopardizing my H1B. They have agreed not to withdraw my H1B. So yeah, the procedure is this, that if employer A can go through in good faith with your H1B filing, and if the H1B does get approved, they can withdraw it. Your employer B can file for an H1B transfer even before October 1st, and your first employer can revoke the H1B, let's say effective October 1st, if they are effective October 2nd, even just to be on the safe side. Then the fact that you have another application pending should go through fine. Especially if you've received a change of status, I think you should be okay. Employer B doesn't have to inform USCIS that you're not working with them. If you receive an RFE, you will have to have that. The H1B has to be approved, otherwise you're still subject to lottery. I really don't have time to go over all the possible permutation combinations, but overall this could work. You should of course be in consultation with your lawyers. They should be telling you what happens next, but I can tell you the generic answer, which is it is certainly possible. It can be organized, especially if the two companies are not enemies. So if you have a quick question, follow-up question, I can try to answer. *5, but I can't go over the entire scenario. There are too many things that can happen. Okay, *5. New York or New Jersey, go ahead, please.
Yeah. So the question is, what if I get an RFE if I'm not working with my H1B filing guy?
Yeah,
how will they answer for that?
They have to respond to the RFE, because until and unless they get the H1B approved, you are still subject to the quota. even if employer B has already filed an application. Although I don't think they can file an application without an approval first. So an H-1B has to be approved with a change of status. Only then employer B can file the application.
Okay.
Okay?
Okay.
Good luck, sir.
Yeah, thank you, sir.
Yeah, you have a good problem. Many people want you. Good luck. Bye-bye.
Yeah.
Okay. Deep impact. I was on L1A, got H4 change of status EAD approved based upon spouse's I-140. Wife already has H1 stamp till July 2019. Want to go for H4 stamping. Project changed. Employer filed for H1B amendment. Can I go for H4 stamping based on her current? See, in these cases, I always like to wait till the H1B amendment is approved. You could potentially go, but this is one of those areas of the law where there is really no law. So I prefer to be very conservative and say, you know what, just wait until it is approved, then go for stamping. Approved or in process. If in process petition has no value for H4 application. So if you try to use the in process petition as grounds for your H4, it won't work. Planning to go to Canada. Can I go to any US consulate in Canada? Technically, any consulate anywhere in the world should be able to adjudicate your H1 visa. But you should always check with the consulates what their local rules are. Centrally, there is no bar on any of the consulates taking your case. So can you go to any consulate in Canada? Theoretically, yes. But a lot depends upon their workload and local policies. So always get in touch with them before you make plans. *5 if you have any follow-up questions. *5. Okay, there is a follow-up question. Let's see. This is from Texas. Yeah, Texas. Go ahead, please. Texas.
It is deep, like Mexico website clearly said that if you are coming to Mexico, you just need to come for a similar visa,
right?
Not changing the visa.
Right. So it is. That's a local rule. That's not a rule given by the State Department.
Okay. I checked with Vancouver, so they are fine. They are telling they do accept third-party nationals with the first time or renewal.
Right, exactly. It's actually called TCN, third country national.
Oh, third country. Okay.
TCN. Okay. Good luck, sir.
So if I am going for the H4, I will be using the current petition only, right?
Right. I prefer that you wait for the amendment approval. I think it's just the more conservative thing to do. But if you have no choice and you have to go, you can try with the existing approval.
And again I need to take the an H1 they ask for the client letter. Again I need to take the client letter for H4 or
no,
not needed?
There is no such requirement, no.
Okay. Thank you so much, Rajiv.
You're welcome. Good luck. US, New Jersey. I have a follow-up question from the previous conference call, question number 15. I don't have that in front of me. Since I have one foreign address on my N400, will that trigger a security clearance from India as well? If I do mail the withdrawal letter for N400, say today, how soon I will be able to reapply for N400? Okay, I don't know what your question last conference call were, and I don't have those in front of me. *5 if you're on the phone. *5. Okay, let's talk to you. Yeah, New York, go ahead. What is the situation? Why are you concerned about the foreign address?
Rajiv, I had, I'd worked in India for around 9 to 10 months last year, and then I came back in January, right? So, so obviously I had to fill that up and bond it. So I was just curious to know, if, being that the case, would that trigger like a security clearance from the countries wherever you have visited?
I don't remember what the rules are off the top of my head. There are just so many rules about so many different things. But if you have been in a country for a certain number of months, I think it's 6 months or more, I think you will need a police clearance from there. But I'm not sure exactly what the rules are. So, and the rules are different for naturalization and for green card. For naturalization, you don't have to submit any police clearances, as far as I know.
Okay.
Okay, I think they just do an FBI clearance for you. So, but for green card, you have to actually submit them. So for N400, I don't think it changes your burden, but it might take them a little longer to get the clearance because it's an FBI clearance.
I see. And Rajiv, normally, let's say, if we withdraw the N400, do we have to wait for it to get accepted, or the very next day?
You can file the very next day. In fact, you can even send in the request and 3 days later file without waiting for the actual withdrawal. Better to wait, it just makes things cleaner. But you can do it even after you've sent in the request. Technically, a request for withdrawal is made effective from the date they receive it, not from the date they act upon it.
I see. And so when we do that, Rajiv, for N400, do we get a letter stating your withdrawal has been accepted, or is this deemed?
Yes.
Okay.
You'll get a letter confirming the withdrawal. Okay.
Okay. All right. Okay, Rajiv. Thanks.
Bye-bye.
Thank you.
Singman, potential situation. Currently on H1B, working at client location in city A. 6 years expires in October 2019. Perm is going on. I may have to relocate to B as a result of my wife's work related to transfer, who's on L1AB, to be with them. If I move to city B, I would be working from home, still the same client, and would be traveling once for a week every 6 months to the client location. Do I need to file for an amendment? Moving to city B, yes, you will. You need to file an amendment. Does it impact my perm processing? It should not. You should double check with your lawyers about that. I don't see any issue with that. So I don't think it should affect your perm, because remember, green card is for a future job. What we require is that if your perm was filed as a location X, and even though you've moved to location Y, you will come back to location X upon approval of your green card. And that's good enough. Okay. Star 5 if you have a follow-up question. Prasad says, according to Charles Oppenheim, EB2 and EB3 dates will move forward in coming visa bulletin. Do you think how far this movement can happen? I don't think I can comment on that. I personally don't see how it can be a drastic movement. Drastic movements are actually a result of miscalculation by the government. And it's a correction. It is not really a true picture of what is going on in real time. You can think of it as a mathematical model instead of an actual real-time model of what is going on. Okay. So I'm not going to comment on that anymore. Last question we have for today. By the way, our forums had some issue. Somebody had started putting in a lot of garbage, and we had to actually get somebody to look at the code and get the code fixed. It took us a couple of days. So people might not have been able to log in. We even tried to restore the database from the few backups, last few days backups, even going as far back as 10 days, but it still didn't work out. So we had to get the code looked at. Hopefully that problem is now fixed. This is Karthikeyan. I transferred my H1B to B from A in June 2016, got 3 years approval, good till 2019. B filed for an amendment and I got it till 2018. Okay, received RFE, responded, denied. So employer A has not yet revoked my petition. Well, you know, USCIS said that you can go back to employer A. Employer A was supposed to revoke your case. But if they have not revoked it, you can go back and work for them as far as I know. Okay. They have not really changed their policy even if you go out of status. Well, you're not really out of status because you were working for the time that you were working for up to 240 days while the extension/amendment was filed. I think you'll be okay. And if you want to be even more conservative, just have your employer call the local congressman's office and have this observation that I just made confirmed through the congressman's office. They can find out from the USCIS if this is okay. And stamping is good. Even if you receive a stamping through employer A and you travel through an H-1B of employer C, that should be okay. If you ask the consulate, they'll say, oh, no, we want you to come in for a new visa stamping. But their own standard operating procedures don't require it. So we've been advising people to go ahead and travel on any employer's visa stamp. *5 if you have a follow-up question, Karthik. *5. Okay. We have one question, and after that we'll have about 24 minutes to do new questions, which is very good. Karthik, go ahead, please.
Hey Rajiv, my question is, if my new employer files petition, can new employer file petition based on my previous employer's approval?
I don't think so. If you went back to work for employer A, worked there for a while, and then filed a transfer over to a new case, I think you could.
Okay. If I went back to employer A, started working, as soon as I started working, can employer C file petition?
I don't see why not. I don't see why not.
Okay. If today I join my employer A and ask my employer C to file my petition, that won't be a problem.
I don't see why not. And that's assuming that it's okay for you to join the first employer. I just want you to confirm that. I think that should be okay, and applying for employer C's H1 the very following day is fine. Why not?
Yeah, the only thing is that I will not have salary slips or anything to prove my current employment.
By the time they send you an RFE, you will have them.
Okay. By the time but they file, I will only have the offer letter from my employer.
I think that should be okay.
That should be. Yeah. That should be okay, right? Okay, Rajiv. Thank you very much. I really appreciate your. Thank you.
Folks, anyone has any question, press *5 on your phone. We have about a good 22 minutes to keep going. Okay, so let's see. I'll go in the order that you guys logged in. First one is somebody from Canada. So let's see. Canada. Let's see. Canada, go ahead, please. Canada.
Hello, sir. My I-824 is approved, but date is blank inside, and they transfer to the NVC.
Okay.
That is should be priority date is mentioned, but priority date is already current.
Yeah, that should be okay. If there are minor typos in the I-824, I'm not worried about it, because your entire file goes to the NVC. They can look at the file and find out what the true picture is. I don't see any issue with that.
And generally, how many days take time to transfer? It's already 30 days past.
No idea. No.
Total entire process, until visa, how long is taken in Canada?
Somebody else takes care of all these details. My job is the legal strategy. So you're asking an architect to answer a programming question. I don't know how to code anymore.
No, sir. Thank you very much, sir.
You're welcome. Good luck.
Bye-bye. Thank you.
Okay, who logged in next? Let's see. The next person who logged in was Illinois. So let's go to Illinois, which is 217.
Hi.
Yeah,
Can you
go
hear me?
ahead. You had a green card spouse question?
Yes. Yes, sir. So we're not married yet. She's out of the country. But she's my fiance, and we hope to get married. So and I know that as a green card holder, I can't do the fiance visa thing.
Correct.
So I was wondering, how would that work if she came to visit, for a couple of weeks or 2 weeks?
I am very, very uncomfortable with people coming to the USA on a tourist visa to get married. First of all, if they come on a tourist visa and they get married and they try to change their status in the USA, that's going to be almost certainly smacked down as fraudulent, because when they enter the USA, they have not disclosed the fact that they're not here for tourism. They are here to change over to green card, number one. Number two, even if they come and they get married and go back, I have a problem if that fact is not revealed at the airport. So at the airport, if they ask you what is the purpose of your visit and you say, I'm just here for tourism, whereas you are here to get married, I think that is a problem. Okay. It is, if you come to the airport and you say, I'm here to get married, but I'm going back after marriage, I think that's okay. If they let you in, come get married, leave, wait for your green card. Okay. But there's no way to keep her here while the green card is pending for the spouse of a US green card holder. And I think entering on a tourist visa to get married is a bad idea. That's my view.
Okay, thank you, sir. The next thing I wanted to ask as a follow-up to that is, so I got my green card in 2014. Okay, so I'm assuming you tell me what you think. Based on the numbers, I think by next year, 2019, based on the 5-year rule, I should be eligible for citizenship.
Right, 90 days before your 5th approval anniversary.
Okay, so that means pretty much maybe February of next year.
Right.
Approximately.
And make sure that you are not stuck in a state like Texas where it's taking over a year for approvals. Just make sure that, and it's also required that wherever you apply from, you must have been living there for at least 90 days before you apply. So you need to be a resident of that state for at least 3-4 months before you apply.
So can I apply from the state of Illinois?
If you move there and if you are living there, yes.
Yes, I live in Illinois, so
wherever
that's
you
what
live,
I moved there last
just check the times in your state and then apply. Yeah, absolutely.
Okay.
All right.
Okay. So okay, I guess you answered to this other question I wanted to ask as far as the eligibility. So do I need to, okay, so I moved to Illinois, to Chicago about a year ago approximately. Do I still need to send update, go to USCIS and let them know my current address?
Always. Until you become a US citizen, you have to keep updating your AR11 every time you move.
So that I can do that on the website, right?
Yes.
I remember that was a form I think I filled.
Oh, yes.
Okay, thank you, sir. I'll do that right away.
You're welcome. Good luck.
Thank you very much, Rajiv. I really appreciate this forum. Thank you very much.
Bye-bye. Okay, so we have 3 more questions left. Next person in the lineup is Texas. Okay, let's go with Texas. Yeah, Texas, go ahead, please. Texas.
Yeah, hi Rajiv. The quick question what I have is, actually I'm working on H4EAD with one of my, with company A, and company B has applied for my H1B for this year, and it was picked in the lottery. So I am, because the current employer is willing to sponsor my H1 for next year, and when I'm asking my the other company who filed for an H1B to withdraw it, they are asking me for additional money. Else what they are saying is if I don't pay them the money, they are going to withdraw the H1B application and make sure that my visa is not being picked up next year or anything. They're going to report me to USCIS. So I'm not sure how to deal with this kind of scenario. So do you think that that's possible?
Okay, you are a lottery case, right?
No, I mean, I'm working on H4EAD.
You are working on H4EAD.
And right now
Hang on. let me ask the questions. You're working on H4 EAD, and some employer applied for your H1 through this year's lottery?
Yes.
You got selected?
And it was, yes.
Okay. So the law is,
the
law is, if they revoke your, if they, for example, let's say the H1 is approved and they revoke it before October 1st, you are still subject to the lottery.
Okay.
So yeah, they can definitely cause your lottery selection to go null and void.
Okay.
Good luck to you. Okay, next one. Let's see. We have last two questions. Let's go to, this one is area code 201. Yeah, 201, go ahead, please.
Hi, Rajiv. So Rajiv, I had a question. So I applied for my N400 in beginning of December of last year. So I just want to know from your current experience, like how long should I have to wait before I, inquire like about my case, like maybe contacting congressman or maybe setting up an like info space.
If you go to the US website, they have a section for times, processing times. You go to the processing times and you select the center where you applied. They'll give you the average time it's taking in that center.
Okay.
Just go to USCIS.gov, USCIS.gov, and look at the processing times. Okay.
So, Rajiv, I checked that. So, for the state of New Jersey, it's saying 9.5 months to 14.5 months.
Okay.
So, do I have to wait like more than a year if I don't hear any update before I can start that?
You can always ask them. They are not just going to do anything for you. You can certainly call the customer service and see what they say. No harm in that.
But what's the best way, Rajiv? I mean, instead of, I just want to know if the security clearance has been received.
You're not going to be able to change the processing time by calling. All you can hope for is that it doesn't get delayed beyond normal time. Certainly, if it gets beyond normal time, you will call them, open a service request with them, and they'll check on your case and get back with you.
Okay. So, Rajiv, there's one last thing. So, when we do call them up whenever, will they be able to confirm if the way the case is at, let's say if the FBI checks are over or
they won't be able to tell you any of that. They have a screen with a very limited information on it.
Oh, okay.
All right. So, it'll take the time it takes.
Okay, Rajiv.
All right. Good luck, sir.
Okay. Thank you. Thanks.
Bye-bye. Okay, then the last question of the day. Let's see. This is Washington State. Why can't I do that? I thought I had just unmuted you. 1 second, sir. Oh, I did. Washington, go ahead, please. Washington.
Hello?
Yes, sir.
Hello?
Yes, sir, I can hear you.
Okay, yeah, I have a question. Okay. So, this is regarding my like H1B portability. I got my H1B through a company like in 2011. My I-140, everything is updated, and I'm waiting for the EB to forever to I-485 to be current for the past 8 years. So they say like I can have like unlimited H1B like 3-year renewals. That was the idea, they said. So when I move from company A to company B, even though they get the H1B approved, do they have to start the green card from scratch, even though they can hold on to the same priority date?
Now, your I-140 is approved, but 485 is not yet filed, correct?
Yeah, they are waiting for the current date. It didn't happen. It doesn't happen.
If you move, your green card has to be started all over again. Okay? You'll keep your priority date, but you'll start your green card all over again.
Okay. So when they process the second one, like if something happens, like 140 not approved or something happened,
you can file again.
It's almost
you
like
can file again.
the latest will be.
You can file again through some other employer or the same employer and still keep the same priority date. Any number of times.
Okay. So this is a burden for most of the people from India.
Actually, it is not. Because,
I don't know whether
no. I tell you why it is. Well, it is a burden. You have to wait this long. But there is a saving grace that because of the January 2017 regulations, once your I-140 is approved and stays approved 180 days, you carry your priority date the moment the I-140 is approved. On top of that, and it's forever. It's not just for one employer. You can use it, and you can use it across categories. EB3 priority date can be used for EB1 or EB2, or EB1 can be used for EB2 or EB3, etc., etc. So you can actually transfer them across categories. They are yours to keep forever. And in addition to that, if the I-140 stayed approved for 180 days and then it was revoked, or it stayed approved anyway, you keep on getting H1 extensions on 3-yearly basis with any employer, as long as your dates are not current.
Okay. So they don't have to. So the new company, do they have to start the green card immediately, or they just can renew
wait as long as you are comfortable with waiting? There is no legal deadline that they have to follow to file your case. They can wait.
Okay. So as long as the company, do you think they have to file the 485 or
they won't file 485. They have to start from perm. They have to start from perm.
Okay. Got it. So it's better to stick with company A, hope that everything is done with the green card, and then get on with it.
I don't think I can make that. I don't think I can make that decision for you.
No. Yeah. What I'm telling is, like, if starting from scratch procedure means it's already a big part. Some people get labor cleared in 1.5 years. I got mine cleared in 30 days, so it was a strange thing. Right. So whatever happened, it happened. So I have to just wait until some miracle happens.
But if you have a really if you really have a good offer, I would certainly consider just redoing the green card. I don't see any problem with that. Okay.
Okay. Thanks a lot.
You're welcome. Good luck, sir. Okay, that brings us to the end of our call today. Guys, as always, it is great to see all of you and talk with all of you. We'll talk again in 2 weeks. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.